Hello, and in this video I want to address the question, what is frustration? So frustration is when an event occurs, the frustrating event, that renders the contract radically different to when it was originally formed. So in such a scenario where the contract becomes radically different, the parties are discharged of their obligations and the contract no longer is enforceable. So an example of this is in Codelfa Construction Limited and State Rail Authority of New South Wales 1992. So what happened is Codelfa Construction Limited, they contracted on the basis saying that this work will be done in X amount of days in X amount of time, looking at the current situation, and obviously New State Rail Authority of New South Wales agreed to this. However, what happened is that the noise and the disruption the work was causing caused the residents a lot of problems. So the residents applied to the court and got an injunction that the company should not work on Sundays. And the court granted this injunction. So what happened is that the work actually took much longer and it costed much more money. And what the court said is actually the contract had become frustrated. Now this is because the contract is radically different. What you do is you have a look at how the parties can perform their obligation after the frustrating event, and actually it was radically different because they couldn't get that whole 24 hours of a Sunday to work, and thus it was frustrated. So what else do we need to know about frustration? Well, it usually arises when there's a supervening and frustrating event, and this event causes one party to fail, and so then the other party will say, oh, has a contract become frustrated, or I want to get damages, and that's when we lead into a frustration type scenario. But for it to be a frustrating event, it's because the doctrine of frustration is a very narrow doctrine. It can't just be anything. It has to be an event that was never contemplated by either of the parties. It can't be self-induced, so I'll have another video on this, but what that means is that one party cannot frustrate the contract because it has to be an event which is unforeseen outside of the contract that completely changes the obligations, because if one party does it themselves then that'll be breach. So it's different in that way. And three, it has to be radically different. So for example, I'm going to give an example now of Davies Contractors Limited and Farnham Urban District Council 1956. Now, in this case, the plaintiffs agreed to build 78 houses in 8 months for X amount of pounds. But there was a shortage of labour and raw materials, and thus the contract was more expensive, so they needed to claim more money and took much more longer. And so they tried to argue that the contract was frustrated, but it wasn't, because it wasn't radically different, the shortage of materials and costs. It just made the contract more expensive, and that's not an excuse. It has to be radically different. And the other point you'll see in the videos with this case is that you can foresee that there will be a shortage of labour or shortage of costs, and you can still fulfill the duty. It might just take a longer amount of time, more expensive, and thus this was not frustration. Similarly, impracticability is not an excuse for a frustration to occur. So, for example, in Movietone News Limited and London and District Cinemas Limited, that just because the war made it more impractical to showcase certain newsreels does not mean the contract has become frustrated. It can still happen. It's not radically different. There's a difference between whether something has become commercially viable, which we saw that in Davies, that it might not be commercially viable anymore, but the contract's not frustrated. And it's the same thing here. Just because it's not commercially viable does not mean it's frustrated. Now, the key point is that the reason why the courts are so narrow with the doctrine of frustration is because they want to keep pacta sunt servanda, that all agreements must be kept, sanctity of contract, freedom of contract, still an integral part of contract law, and they don't want to intervene and reduce the commercialness around contracts. Please visit my blog.